You submitted your Form Y-130 14 months back. Your spouse is a U.S. citizen. You've shared 6 years of life together and 2 years of marriage. And last Tuesday, an envelope arrived from USCIS. It wasn't the green card approval you were waiting for. It was a 12-page request for evidence, asking for jointly filed tax returns stretching back to a year before you even shared a home. A notarized letter from your landlord and proof that a visit you made to see your mother wasn't some kind of hidden second life somewhere. You have 30 days to reply. Your lawyer, if you've hired one, is telling you to stay calm. And somewhere on YouTube last night around 1 in the morning, you typed a search that brought you here. Does filing a marriage-based green card put you on a path to deportation? That used to come with a simple answer. In 2026, the answer is no longer simple, and by the end of this, you'll understand exactly why and exactly what to do about the letter sitting on your kitchen counter right now. Here's the real shift, stripped of legal jargon. On May 21st, 2026, USCIS issued a document formally titled Policy Memorandum PM 602-0199. The headline alone reveals the thinking behind it. Adjustment of status is a matter of discretion and administrative grace and an extraordinary relief that permits applicants to dispense with the ordinary consular visa process. Pull that out of government language, and it means this. USCIS now treats getting your green card without leaving the country, which is what adjustment of status is, as a courtesy they can extend to you, not a benefit you locked in by meeting the rules. Before this memo, if you met the legal criteria, genuine marriage, no disqualifying issues, clean filings, approval was close to automatic. Today, an officer can review your full file, decide you technically qualify, and still turn you down, because the standard has shifted from "did you clear the bar" to "did you clear the bar?" And does this officer, exercising discretion, believe you merit extraordinary relief? That distinction might sound small. It isn't small. It's the line between a checklist and a judgment call. So, does that mean filing puts you on a deportation track? Not directly and not automatically. But here's the part almost nobody spells out clearly, and it's the part that matters most. If your adjustment of status gets denied and you are what's called removable, meaning your underlying legal status to remain in the country, independent of the pending application, has already expired, USCIS can issue or refer your case for a notice to appear. That is the document that starts removal proceedings. It isn't a punishment for filing. It's a consequence that was always technically possible, but under the old framework, it rarely got triggered because denials were rare and usually procedural. Today, with discretion driving more denials, more of those denials are landing on people who are also separately out of status. And that combination is what's pulling filing and deportation into the same sentence for the first time in years. Picture 3 people watching this video right now, because odds are you're one of them. First, the spouse of a U.S. citizen filing from inside the country who entered on a visa that expired 18 months ago. That's the composite case behind the RFE. For this person, having a real marriage is no longer the whole battle. The file needs to actively build a case for favorable discretion, meaning documented family ties, community involvement, tax history, the kind of paper trail that used to be optional and now functions like a shield. Second, picture an employment-based green card applicant, someone on an H-1B with a company sponsoring their Form Y-140, waiting on a priority date, who assumes none of this touches them because they're not in the marriage-based lane at all. It touches them too. USCIS has signaled that category-specific guidance is coming for employment-based and parole adjustments next, and the discretionary posture of the memo isn't limited to spouses. It's a philosophy shift across the whole adjustment of status system. Anyone with a gap in their status history, a past denial, or an employment authorization lapse is now more exposed than they were 12 months ago. Third, picture a student on an F1 who just married a U.S. citizen and wants to adjust status without ever leaving. This is where people make the costliest mistake on the list, and it has nothing to do with the marriage itself. It's leaving the country before advance parole is approved. Under the regulations, if you depart the United States while your Form Y-485 is pending and you haven't secured valid advance parole first, your adjustment application is generally considered abandoned the moment you cross that border, no matter how strong your marriage case was. People still do this every month, usually for a funeral or for a sick parent, not realizing the timing wipes their entire case to zero. Departing while your Form I-485 is pending without an advance parole document is one of the single most dangerous mistakes in the whole process. Why is USCIS doing this? Not because marriage fraud suddenly spiked. The stated justification is administrative. The memo frames consular processing abroad as the ordinary path Congress intended, and adjustment inside the U.S. as the exception. So, tightening domestic adjustment is being presented as a return to that original design rather than a new restriction. Whether that legal theory holds up is genuinely contested. This is an interpretive memo, not a statute passed by Congress, and it wasn't run through the standard public notice and comment process that regulations usually require. That matters because interpretive memos are more vulnerable to court challenges. And there is real litigation forming right now from applicants who made major life decisions, quitting jobs, signing leases, having children, based on the older, more predictable standard, only to find the rules rewritten under them mid-case. Which brings us to the mistake you're most likely making right now without realizing it. And it's not about your marriage at all. It's about your paperwork sequencing. People are still submitting Form I-485 packets the way they did in 2023. Marriage certificate, joint lease, a few photos, done. That worked when adjustment was close to a formality. It does not work today. Every adjustment applicant also needs Form I-693, the medical exam completed by a USCIS designated civil surgeon, submitted at the time of filing. This has been required since December 2, 2024, and incomplete or missing medical paperwork remains one of the fastest ways to trigger an RFE that eats months off your timeline. On top of that, if you're filing Form I-130 and Form I-485 together, concurrent filing, expect the Form I-485 decision to take roughly 8 to 14 months on average right now, though that swings hard depending on your local field office. Interviews, which had briefly been waived for more straightforward cases, are back to mandatory for essentially everyone. If speed genuinely matters for your situation and your case touches an employment-based category that's eligible, certain Form I-140 and Form I-129 categories are currently eligible for premium processing at an increased fee in 2026. But check the live USCIS eligibility list before paying anything. And remember that expanding premium processing to certain family-based petitions is something that has been discussed but is not broadly available in the way many online posts suggest. Premium processing moves one piece of the puzzle, not the whole board. Here's something almost nobody tells you, and it's a genuine reversal from what you'd expect. The discretion memo is not a death sentence for well-documented cases. Look back at Matter of Arai, the decades-old precedent this discretionary framework actually leans on. It holds that favorable discretion generally follows when there are no adverse factors, and where negative factors exist, they can be offset by positive equities like family ties. That framework hasn't changed. What's changed is that USCIS is now applying it more aggressively and to a wider set of cases. A genuine marriage backed by real financial entanglement, a consistent shared address history, and a clean immigration record remains a strong case under this memo. It just now needs to prove itself instead of being assumed. So back to that RFE on the kitchen table and the question that's been unresolved this whole time. Will filing get you deported? The honest answer is that filing itself never deports anyone. What creates risk is the combination of a discretionary denial plus an independent pre-existing removability problem, meaning your status was already precarious before you ever touched Form I-485. If you entered legally and maintained status up to the point of filing, a denial under this memo is a serious setback, but it does not automatically flip into a notice to appear. If you're already out of status, the equation changes, and that RFE stops being routine paperwork and starts being the most important document you'll respond to this year. If you're in this spot, here's what I'd tell you plainly. Don't treat your RFE deadline as a formality. 30 days moves fast, and a rushed, thin response is worse than a complete one filed a week later if that extra week gets you real documentation. Build your file like you're building a case, not filling out a form. Joint finances, a consistent shared history, community ties. Everything that an officer weighing discretion will weigh in your favor. And before you make any decision involving international travel, confirm your advanced parole status first, every single time, no exceptions. Because that one mistake has ended more strong cases than any RFE ever will. This memo changed the temperature of the whole system, but it didn't change what makes a marriage case succeed. It just raised the bar for proving it. If this helped make sense of what's actually happening right now, subscribe because next I'm breaking down exactly what USCIS officers are looking for in a discretionary approval under the new standard, line by line. The part almost nobody is explaining correctly. This video is general information, not legal advice. Immigration outcomes depend on the specific facts of your case, the policies discussed continue to evolve, and viewers should consult a licensed immigration attorney for guidance on their own situation.